Hello, everyone, and welcome to today's program. My name is Laura Cox, and I'm with the Association of Corporate Counsel. When you entered, you should have noticed a gray control panel pop up on your screen. Within this panel, you'll find a chat tool called Questions. Please use this chat tool to send in any questions you have for today's panel. You can also use this tool to send in any technical questions you may have for ACC staff. Also included in your control panel, you'll find a section called Handouts. Today's presentation materials are available there. Please note, for those of you who are viewing this for CLE or CPD, there will be 2 verification codes given out during the program. They will appear in your chat box, so please keep an eye out. You'll need that information later. Make sure you write both of those codes down and enter them on your evaluation at the end of the presentation. You can find your evaluation in the My Account section of your ACC online education page. You should then receive your certificate of attendance immediately. If that doesn't happen, you can send us an email at webcast@acc.com for assistance. That's webcast@acc.com. And now for today's panel, we have Linda Metz. Linda is a patent, trade secret, and trademark litigation partner at Brooks Cushman. We also have John Rondini. John is co-chair of cybersecurity, patent litigation, and post-grant proceedings at Brooks Cushman. And as our in-house panelist, we have Deanna Kwong. And Deanna is senior IP litigation counsel for HPE. I'm going to turn things over to Deanna to get us started. Take it away.
Great, thanks so much, Laura. Good morning, everyone. My name is Deanna Kwong. As Laura mentioned, I'm senior IP litigation counsel at Hewlett Packard Enterprise Company, and my team is responsible for managing all litigation matters around the world involving patent, trademark, trade secret, or copyright, as well as pre-litigation intellectual property disputes as well. I'd like to now turn it over to Linda and John for brief introductions of themselves as well.
Hi, I'm Linda Mettis. I am an intellectual property litigator. I've been doing predominantly that for 20 plus years, handling all different kinds of technology, as well as, cases ranging in the few $100,000 for a copyright or design patent type case over to hundreds of millions, even $1 billion in damages over the course of my career.
And my name is John Rondini, and as the introduction stated, I am also a patent litigator here at Brooks Cushman. Have been doing patent litigation for over 10 years. I was part of the team that helped found and start our post-grant proceedings practice back in the early days when it was first getting going nationally. And I also am now the co-chair of our cybersecurity and data privacy group.
Great, thanks so much, John and Linda. So today we thought we'd cover 4 main areas. The first of which is how to prepare for upcoming litigation. So when a demand letter comes in from a competitor or non-practicing entity, how does a company address that pre-litigation threat? We will also talk about opinions of counsel, when to obtain those, practice pointers on how best to formulate those. Secondly, we'll cover how to manage outside counsel costs, particularly as budgets in-house get increasingly tighter. How can we be more cost effective with the increased cost of patent litigation in particular, which is often the highest exposure and most expensive lawsuits that a company faces. Third, we'll discuss administrative proceedings and their impact on and intersection with district court litigation. In particular, we'll focus on post-grant proceedings with the PTAB and the International Trade Commission litigation as well. And fourth, we'll focus on choosing the best value. So turning now to our first topic of how to prepare for upcoming litigation. John, do you want to start with demand letters and how to address those when those come in?
Sure, thank you. So the first thing is, that usually typically happens in any type of high stake litigation or before high stake litigation, as Deanna indicated earlier, is usually a demand letter or some type of threat letter is received by a company. And these letters can range all over the place. They could be a simple short letter where a party is just saying you may find X patent of interest, or it may be more adversarial where they're actually asking you to cease and desist usage or production of a certain product based on certain IP. And so that gets into the first thing. When you receive one of these letters, the first thing you need to do is you kind of need to analyze the strength of the demand. And the first thing we typically do, or we do with our clients, is we look at the patent owner, and the letter will have a patent in there, and you look at the patent owner, you might look at their litigation history or the propensity for litigation. And this helps you to know the adversary. You want to investigate who's filing the lawsuit. Is it an actual competitor? Is it a non-practicing entity? Is it a subsidiary of a branch of a bigger company? And the reason you do this is this really helps you to kind of understand the real purpose of the demand, why the demand was sent to you. And a lot of times you'll start to get a little bit of information about if it's a non-practicing entity. Maybe there was a blanket letter sent out to a bunch of companies and they're looking for quick settlement from everybody. And that's kind of how you want to start to analyze the strength of it. You want to look at the commercial relationship between the patent owner and the recipient. So there you might want to look at the patent, look who the original inventor is, look at who the assignee might be, and then look at who the letter sent from. Typically, in a lot of cases now, the original assignee might not correspond to who you receive the letter from. And that happens a lot where you get a letter from a non-practicing entity. They might have bought a subset of patents from a now defunct company, or possibly a still actively operational company that has sold off a portion of their IP, and through various acquisitions, some non-practice entity has gathered those patents, and those patents might have legitimate strength in the industry. It's just not owned by company X anymore. Now it's owned by a non-practicing entity. And that is something that you really want to take a look at, because if it's something that's directly in the wheelhouse of your product line or what your company focuses on, and the patents that are now being identified in this letter, fall right into the commercial space where you operate, that is something you really want to, take a close look at. The other thing you might want to look at is the established profitability of the infringing product. If it's a low market, low volume product that you're selling, that's going to really help you analyze and inform people at your corporation what the strength of the letter is. If it's low volume and they're asking for a very low license, that's something that's going to be a business decision. It might not be palatable all the time, but sometimes the cost of litigation and the cost of pursuing some of the options we'll talk about a little bit further on are outweighed by the low settlement offer. And sometimes it's easier just to settle with these demand letters and move forward, as opposed to waging all-out battle in litigation.
And this is Linda. And one other aspect to look at when you're looking at the infringing product is that in a lot of situations there might be indemnification at issue, that you might need to make an indemnification demand at a certain time to see if somebody else might be covering some of the costs.
That's a great point. The points 4 and 5 here we'll talk about in a second, but if there's some strength with the allegations made in the demand, if the patents are something, if it's from a competitor and the patents are a strong grouping of patents, or if it's from a non-practicing entity that has a known propensity for filing lawsuits and going the distance on the lawsuits, you may need to go to looking at the strength of the infringement allegations and the strength of the asserted patents. And the way that typically happens after the demand letters is presented is through opinions either of in-house counsel or outside counsel, and we'll talk about those different types of opinions in a second. And then the last one is just what is the demand? Are they looking for a license? Are they asking you to cease and desist? And these type of if it's a license offer, that's typically you may want to reach out to some of your allies that are out there at different companies and see if they've received a similar threat letter, and or look at litigation history and look at if there were settlements, just post filing of a complaint. So that way it'll give you some indication of, what the demand is really about. Is it really about a quick settlement and they just want you to pay some money, or is it something you're going to have to inform people at your company, no, this could be a dragged out patent litigation. So that's the starting point with the letter, is you really need to analyze what the letter is, the strength of the patent owner's litigation history, and inform people at your company where this might head.
And if it's a trademark or a copyright suit, which, you know, typically have somewhat lower stakes, but not always, especially for mid-sized companies, there's also the possibility of insurance coverage.
Yeah, this is Deanna. So just to add an in-house perspective on this, so I was in private practice doing patent litigation for over 11 years before I went in-house. And one of the most surprising things for me when I first went in-house was just the broad spectrum of comprehensiveness and quality and strength of demand letters that companies get. We would get some really laughable, arguably entirely frivolous, short letters from inventors themselves, or even small companies, or directly or law firms representing such individual inventors or companies, with very weak, bare-boned allegations. Sometimes they wouldn't even specify the specific products they were accusing in our portfolio. So that was actually one of the things that really struck me when I first went in-house, was just the sort of below, before you get to litigation, before you retain outside counsel, just some of the random demand letters we get. And just adding one additional factor that we often analyze in looking at the strength of a particular demand is also the outside counsel, if outside counsel sent the letter, who's representing either the competitor, and in many cases the non-practicing entity. A lot of times, if it is, for example, counsel that historically has represented a lot of NPEs, and we know from prior cases are taking those on contingency basis, that may inform our strategy and whether we respond or not, or the strength, in our view, of that particular demand. And we also may, especially sort of given the potential administrative challenges now, take a quick look at low-hanging prior art, for example, or whether we have our own patents that cover the accused technologies that we can either, counter-sue on or counter-demand on if it's a competitor making the demand, or just assert as, potential invalidating art if it's an NPE or a competitor.
Those are all fantastic points. Thank you, Deanna. And playing into some of the points you just raised, and what you do once you've analyzed the strengths, is the first bullet here, is the very simple one, the do nothing, and kind of plays into what you're just talking about, Deanna, with, the letters that you receive. I'm in-house. I know we don't always receive all the threat letters that I'm sure companies receive, but because, like you said, you get such a wide variety, from the almost laughable to the, the real true demand threats. And the laughable ones, or the ones with the low likelihood of success, you may want to hold back on and wait for them to come back. And actually, if they didn't identify a product, like you said, sometimes they just send a letter and they say, we have this patent, you may like, or it may be of interest to you. Well, interest how? Interest why? And until they come back and they give you some reason to do something, sometimes it's not worth spending the time on, because a lot of times these entities may never come back. They might send out blanket letters to a couple hundred companies and just wait for one person to bite. The other thing you could do is if it's a little more engaging of a letter and it's from a legitimate, outside counsel or from a competitor, you may want to reach out and request more information about why they think that patent or your product infringes a given patent. And you may want to request some type of claim charts or some more information from them beyond just the letter that they sent. The next couple are starts to get into, now we're talking a little bit more of the actual litigation posture, seeking to invalidate the patent. And there's various ways you can go about doing that. You could do that in a declaratory judgment action. That is not, of course, the advisable course of action in today's climate, given that if you do that, you're risking not being able to file a inter-party review action at the patent office. So typically you could file a DJ of non-infringement, or you can seek to invalidate the patent at the patent office. And the last one's always the easiest. You could take a license if the demand is either one that you're afraid that there's a great likelihood that they could succeed, or if it's one where the demand is so low that the cost of the license is greatly outweighed by the amount of costs that you would incur going all the way through litigation or trying to invalidate the patent. So these are just a bunch of factors. None of them are the right one. Every factor kind of fits a certain scenario, and like Deanna stated, I mean, you get all these different types of letters, and how you respond kind of really depends on what the letter is, the strength of the letter, and your full analysis of the letter and what you think is going to happen next steps.
Yeah, and this is Lynn. You just have to measure the risk that, using your common sense sometimes with these letters. And there are times that the do nothing is the right course of action. And then something comes to head like 3 or 4 years later. I mean, there have been so many times the cease and desist letters come and absolutely nothing happens for a very long time based on a number of factors or something. And there are so many times that absolutely nothing ever happens. But in some cases, the factors would point towards potentially responding, but one thing tips it the other way is that you find out that all people in a particular industry got this type of letter. And you might be a mid-sized company and you might want to sit back because they're probably going to either choose like the smaller companies or the bigger companies to go after. And they'll file the IPR and they'll do all of that. And then, all you need to do is really just maybe get the opinion letter that we're going to be talking about and monitoring.
Yeah, those are really great points, Linda. I want to segue a little bit into what you just said about using opinion letters to avoid liability and limit exposure. Can you talk a little bit about when a company might want to seek such an opinion and the types of opinions that they can obtain?
Sure. So actually segues right into the next topic, why you would need an opinion. And the most important reason why, so let's say we're talking about just receiving a threat letter. The opinions can help shield you from a willful infringement allegation if a lawsuit is brought. And that's the most important reason. But that's not the only reason. Another reason you may want it is it helps provide in-house counsel some talking points when they're talking to the different business levels within the organization about the potential risks of a lawsuit. Whether or not there is some strength to the infringement allegations, whether or not the validity of the patent is suspect, or whether it potentially has a lot of strengths and it's gone through the inter-parties review process already and it's survived and the claims have been found valid. I mean, that may be something that you'd really want to inform other business units about, and that gets back to whether or not you would want to really start to think about taking a license or moving forward with potential litigation.
Yeah, we talk a lot about like getting an opinion to protect from willfulness, but one of the most basic reasons to seek advice from your attorney is just to start to get a handle on your risks that are involved, the basic what do I do here kind of stuff, and maybe create a strategy. And an early strategy is sometimes really crucial and helps inform, all the way through appeal. But when we talk about opinions, it doesn't have to be a written formal opinion. That written formal opinion really is often for protection against a willfulness claim, or to make, you look a little bit better at trial, put a little bit of a white hat on. Like I talked to, an attorney and we were fine. There was no infringement here. But even short of that, the oral opinion and just getting some initial take on like what's going on with this particular plaintiff, with this particular patent, and the outside counsel is crucial.
It is. And one point with the written opinion versus oral opinion, in today's climate in district court litigation, the opinion doesn't have to be some formal 50-page opinion with, a legal analysis section, a formal introduction, and formal analysis. It could be, a very well put together PowerPoint presentation. It could be a very short memo or letter. When we say opinion, it doesn't have to be, a $50,000, opinion from counsel that took weeks upon weeks to develop. It could be something short, because sometimes you're pressed for time and you need a quick response to Linda's point that you need to not only start to analyze the risk and develop a strategy, but you need to inform the other business units. So sometimes the more informal opinion that's good enough to at least hold yourself out post halo as you sought the advice of counsel, you had a good faith belief that you didn't infringe or there was invalidity aspects to the patent, and that's enough. So it's always good to have the more formal opinion, because when you get in court, you'd want to hang it just like they're going to take their patent with the pretty ribbon and hold it up. You would want to have a nice, well-written opinion, but it's not mandatory, is what I'm getting at. And so that leads into the different types of opinions that you could seek, and a couple are offensive patent or opinions, and a couple are defensive. And I'm just going to quickly just touch on the offensive, and we're just going to kind of move past those, because that doesn't really apply with respect to whether or not you've received a threat letter. And particularly the first one, the protectability opinion, and then you have a clearance opinion, and then you have your 3 defensive one, and we'll spend a little bit more time on those. But the first one, the protectability opinion, that's typically something you may do well before you ever receive any type of threat letter. And it's basically just trying to see if you can carve out in the IP space, whether there's any type of IP in a certain product area that you can carve out and have some type of meets and bounds protection, that if you ever receive a threat letter, you have something where you could potentially cross-license or counter-sue on in case you receive a demand letter, and in case you ever need to use that type of IP against another person who's alleging infringement.
And this goes back to what Deanna was talking about earlier too. I mean, not necessarily the protectability opinion, but you always want to assess whether your product is covered by its own patents. And so that's something you want to do as you see things potentially heating up, is make sure that you are protected, because as a defendant in litigation, in a patent litigation, you really want to be able to say, my product that you're accusing is covered by its own patents. It may not be relevant, just like motive isn't, relevant in murder, but it really is crucial to, how a jury views a defendant.
That's very true. I mean, a lot of times just having any type of patent that you can raise and say, no, we don't infringe their patent. And as a matter of fact, the patent office gave us our very own patent on our product. And so therefore we can infringe because we have our own patent. That's legally not always true. I mean, and we know that just because you have your own patent doesn't mean you can't infringe somebody else's patent, but in the jury's mind, it does mean a lot.
You find a way to make it relevant and you get it in the case through damages or whatever, but that's the jury thinks. The jury thinks, well, they have their own patent. It comes up in every mock jury analysis. And also, it can't go without saying, is that in high stakes litigation, it's really good to have your own patents to even enforce and counterclaim on, and it may make someone stand down. In fact, in many industries, the big competitors don't sue each other because of those patents. They don't even have to say it. It's just sort of known. If I send that cease and desist letter, I'm just going to get one right back.
So the other type of what I'd call offensive opinion is another one that you may get, or you may seek before you receive a cease and desist letter, is just a clearance opinion. And typically, you may do this if you know you're entering a certain market space where there's the potential, once you enter it, you're going to receive a threat letter. You may want to try to avoid some of the landmines. You may want to try to weave around some of the problematic patents or trademarks that are out there. And so in order to do that, you might want to seek the opinion of counsel to help guide you through that landmine. And they tell you the risk of infringements with certain products that you're seeking to introduce. And that helps you avoid unnecessary expenses. In particular, a cease and desist or possible litigation that would occur if you don't try to clear it before you enter the market space.
And I mean, there's always the downside here, is that sometimes you don't want to know about those other patents out there for willfulness reasons. And so that's sort of a strategic consideration. Do you not want to know, or do you want to know what's out there? And, most people tend to want to know so that they can make the plans that they need to make. But there's always that concern.
That's true. And typically, a lot of times when we do clearance opinions, it's because somebody entering a market space already knows that there is a sector of, or a grouping of patents or potential problematic patents already out there. And they really want to try to avoid those patents, especially if they're entering into a market space with a competitor that has a large portfolio in that market space.
Yeah, this is Deanna. One practice pointer to note on protectability opinions, clearance opinions, or other offensive opinions is to make sure you vet or think about whether those opinions were commissioned in anticipation of litigation, if there is actually a present threat at the time. And if so, then, assuming there were a lawsuit down the road involving that area of technology where you'd be obligated to produce that, perhaps. So give some thought to that. I know a lot of times in-house, the offensive opinions are commissioned or worked on by the IP team or the patent portfolio managers, and not necessarily the IP litigators at the company. And so it sometimes is prudent to get litigators involved, even if there is no actual litigation active at the time, to advise on that, or to just give that some thought, because I know there have been some cases where we've had attorneys in-house work on such offensive opinions or hire outside counsel, and then down the road realize that those communications may not necessarily be able to be upheld because there was no attorney work product doctrine in place, because there was no actual anticipation of litigation at the time.
Yeah, those are really good points. And you just, I don't know that there's a pointer out of this, but I remember a junior person finding some patents and then feeling like, that outside counsel needed to look at them because they now knew about them and they were about to purchase some products for sale from China into the US. And so the upside of this was that we did have concerns. We didn't do a written opinion, did an oral opinion, but there were options and there were non-infringing options. So it turned out to be a good thing that the junior person found something that the more senior person's like, oh, darn, now I have to look at this. But it ended up being good for the business people because there were actually, it changed the course of which options that they were sourcing.
And one other point, just to follow up on you, Deanna, that I've experienced in the past is, and this is something just to keep in mind with the offensive type of opinions, is, some people think, well, I'm just going to get an opinion, or I'm just going to go to my head of my engineering group and I'm going to have him write up something about this. I'll have him look at the patent and have him give some analysis on the product. And to the point you just raised, Deanna, that's been problematic because there is no work product doctrine there. It was written by a non-attorney, maybe not completely at the direction, and you raise a lot of issues there. And if the engineer writes it in such a way that's problematic for your infringement case or your invalidity case, and uses strong language like, our product definitely satisfies the claims of this patent, that's really potentially problematic, in the litigation. I mean, even if it's completely inaccurate because it's not legally based properly, it becomes problematic in the jury's eyes, because the jury's, all they see what an engineer at that company stated.
Yeah, and I think mid-sized companies tend to do that, and I have seen that often, like during discovery, and they don't even have to go so far as saying that this might infringe. Or I've seen what they do is they'll go through some claim language and they'll check which boxes, which ones are there, and even though some boxes weren't checked, it was very damaging in the litigation for that company. But what I find just as troubling is once the engineers get involved and they see the patents, they start to incorporate the language from the patents into their own product. Like they'll start to use language from the claim to describe their own product. And then once those are produced, it's very hard to get away that product does not meet that claim limitation.
So with that, we'll talk real quickly about the last two, which are the more pertinent types of opinions you might want to seek after you've received a demand or threat letter, and that's the non-infringement and invalidity opinions. And the two of them, while different in scope, kind of go hand in hand, and based on the patent, it might depend on which one you go with. The more standard one to go with is typically the non-infringement opinion. It's more focused. It's one where you take a look at the product, you take a look at the patent claim, you'll look at the file history, you'll try to do some analysis and determine, you're looking for the limitation that the product just doesn't meet. And it becomes a very simple analysis if you can go through and do the analysis and take a look at the claim language and the product. The invalidity is always a little more difficult because there you got to find some prior art that meets all the limitations of the entire claim, and not only the asserted independent claim, but you're going to have to do the dependent claims too. So those tend to be very much greater in length and cost because of the amount of analysis that has to go into it.
For non-infringement, you just have to find one claim limitation that's not met. You always want to have the additional caveats that there are others, because in litigation, you don't want the opinion that you're using to make it seem like that the position that you're advancing in litigation was never even thought of until later, after the fact. But I think that the most important pointer in terms of non-infringement opinions, and I've seen this where we can't even use opinions in litigation because the information provided to the attorneys wasn't complete or accurate about the accused product.
So with that, I mean, we just talked about invalidity, so we're gonna slide past this one. And the only last point I wanted to raise with respect to opinions is, and I know we talked about it briefly at the beginning, is about the oral opinion aspect. There is case law out there, you know, about is an oral opinion, if you get a threat letter and you seek opinion of counsel, and the opinion of counsel is just oral. Generally, that should be, you know, enough to help shield you somewhat from a willfulness allegation, but there is case law out there where that wasn't enough, and the court, you know, right or wrong, had held that you didn't get a written opinion. And like, again, I go back to saying the written opinion doesn't have to be the formal, you know, long 50-page opinion, but at least a memo, an email, something back to the attorney that you can say, yes, I spoke with counsel, he told me this, as a matter of fact, he followed up in the email, and here's the email. Something that you can hold up and state you've gotten some opinion of counsel, and it's just not your word, you have some written documentation of it. So it's always better to get something back from counsel, you know, with respect to your opinions. And with that, I'm gonna let Linda talk a little bit more about managing costs and pressing settlements.
Yeah, and one of the reasons why we chose the order that we did was because it's a segue into the cost considerations, because in-house counsel and outside counsel can't work together to manage the cost without sort of knowing where the strengths and weaknesses of the case are, as well as a little bit about who the opposing, you know, plaintiff is and outside counsel, and sort of what their practice has been. And what I'm going to talk about is sort of more general cost considerations of sort of a typical patent case. And we're going to talk a lot more in a bit about the interplay of IPRs and ITCs, because they can really throw things askew from the traditional. And that's been happening a lot more recently. But the first thing is, after the opinion of counsel, and like I said, not written or oral, just, I mean, when I say opinion of counsel, whether you got a cease and desist letter or a complaint, the first thing that has to be done is an analysis of the situation, analysis of the infringement, the product, the same things that John went over, you know, the validity and all that other things. And then you can start to create your strategy. So having done that early, or monitoring another situation, and now you're, you know, being dragged into the fray, there should be some like communication early with the client regarding, is this something that they want to, you know, take to the mat? What's the likelihood of trial? What kind of settlement strategy do you want to put into place? Because that's really going to help understand and inform how much is going to be spent and where the focus of that money is. And again, you know, this is talking about sort of high stakes litigation. I mean, there's always, you know, these low stakes cases where you might settle very early for less than the cost of litigation, but there's almost an assumption here for us that, you know, some money is going to be spent, and you're needing to get some proofs in place, you know, that litigation has started to convince the other side to settle, to get the plaintiff and defendants, you know, expectations close enough in line that they can come to an agreement. And in that aspect, it's really important to consider, you know, when you're the analysis of non-infringement, the analysis of the patents that are out there, and how strong the, you know, the validity arguments are. How, even whether you look like the guy wearing the white hat or the black hat. I mean, do you have some bad documents out there? Do these things affect, you know, like, you know, what a jury would think of your company when, and a lot of companies are just litigation shy. There are plenty of companies that are not litigation shy, but some that even if they can win, they want to avoid public litigation and the costs and burden on the company of litigation. It's more than costs, it's the burden on the employees and the time away from actually making money. But taking all of that into account, there's a lot of places to think about costs and the way to put on different parts of a case. So for example, you know, it may be that this is a case where fact discovery can be minimal, and you're really going to put more weight on, you know, experts. Or you might decide that you really just want to see, there could be a dispute on claim construction, but it could all fall out if the claim construction ruling is favorable. And they're here for whether that's a competitor or a non-practicing entity. Claim construction can be really important, and depending on the venue, you may be able to get that decision early, because overall, the early settlement is the best case management device. Being able to get to early settlement and paying the plaintiff versus paying the lawyers will be cheaper in the long run, unless your case is really strong. And then there are plenty of situations where companies decide that they would rather fight it out, that the product at issue is very important, that the case is weak, that the plaintiff will just come after them on more things, and so they need to make a stand. There's a lot of factors that can go into a decision to basically take it to the mat. And so in that case, that's just something that needs to be communicated, including a discussion of where the best use of money is. And sometimes, in some cases, if there's multiple defendants, you can sort of sit back and divide up the work, which we'll discuss. But it's almost sort of like you need to just, that needs to be determined from the beginning, sort of the likelihood of trial and the likelihood of settlement and where a settlement can happen. And one of the key problems I see in settlement, in terms of talking about alignment of expectations, is sometimes outside counsel has to do quite a bit of work managing their own clients' in-house counsel's expectations, because the case could be really, really weak. In-house counsel gets really tired of, hearing anything can happen at trial. There's always a risk, things like that. But what I have found as a bigger impediment to settlement is often trying to figure out the other party's expectations. Or you go to the first mediation and their expectations are completely out of whack, and they just want too much money, or they think their case is too strong, and they don't see the weaknesses, and you're not communicating with them directly. So going to the next slide, I think that this is an anatomy of a typical patent case, taking out the IPR and ITC and all these other things that can throw things askew. There's certain places that you can communicate and apply pressure towards settlement. So for example, the first thing is right at the complaint. And there's definitely been situations where neither party really wants to spend that much money on attorneys. They're competitors, and they actually have a good mediation, a good mediator, or I have done it with just outside counsel. And we talk about, the strengths of the case, and the parties come to some kind of an agreement, whether it's be licensing or business decision, a purchase of parts, things like that, that can avoid litigation. Beyond that, typically the scheduling conference is a really important place to sort of set the tone with the judge. By that point, there should have been a pretty deep conversation with, in-house counsel about what their goal is for settling. So if it's an early settlement, you want to push for fast mediation. If you think that you sort of need Markman, you need claim construction, then you tell the judge, set the mediation after claim construction. But that is where the judge, that's your one chance to, make your first impression with the judge and get them on board with that. Another thing to do at the scheduling conference is sometimes for a non-practicing entity, or even like a dug-in competitor, they may have this long list of fact discovery. They're sort of like hanging over your head. And so it sort of sets a tone with the judge that maybe this case doesn't need that much fact discovery, just to sort of set the tone that will not play into the cost as much, and get them on your side. But Markman is bold because that is the absolute kind of first place where things will fall out. The judge will have an opinion, and it'll be clear as to the strengths of each party's case. And the other thing about Markman is typically it precedes a very expensive period. The fact discovery and expert discovery period is very burdensome, both in time and money. And so Markman is a good time to start to apply pressure. The next one is summary judgment and Daubert. And there, the thing with summary judgment and Daubert, I've seen plenty settle before the summary judgment ruling. The fear of a summary judgment ruling has settled plenty of cases. And that's the first time to really, truly communicate the strength of your case to the opposing side. And they become involved. And by reading those papers and participating in their own declarations and their depositions prior to that time, they may start to understand that they have their own deficits and would be willing to settle, and they don't want to take a risk at losing at summary judgment. And then there's always settling right at pretrial, right? Everybody's getting worried about trial. And then obviously post-trial appeal. And I've certainly seen settlement in high stakes litigation after appeal. I've seen cases where you then file actions against the other party to manage things, and also appeal. But talking about managing costs, one key thing in high stakes litigation that's very unique to patents is joint defense group considerations. Because often, litigation between competitors is different than non-practicing entity litigation. And when non-practicing entities are involved, there's typically suing multiple parties. And even though they can't join everybody in one suit the way it used to be done, they'll file complaints in the same district court against multiple parties. And the courts, in their docket management wisdom, often put them on similar paths and have claim construction and fact discovery and a number of items along the way all joined together. Joint defense group considerations, it can actually save a lot of money if you're willing to give up control. If you're willing to divide the labor and let one person handle invalidity, another person may be handling unenforceability, another person handling a different invalidity theory, you're going to lose control, but you're going to save money. One aspect of joint defense group considerations, though, is to manage, because the amount of coordination sometimes can actually increase costs. In fact, often can increase costs, because rather than just write your own claim construction brief, now you have to have all these calls and coordinate with somebody else because you've got one brief that everybody has to write. But strategic division of validity challenges is a key one and can really play into the IPR district court considerations.
I was going to say, just real quick on that last point, the strategic division of validity. One thing I have run into with joint defense counsel, where we split up the validity challenges and we handled it, was a multi-patent suit, and we had different experts handling different patents. I've actually seen the problem where during the deposition of one expert, the counsel might run askew and try to, even though he's a validity expert, they might try to start posing and try to do infringement analysis with him. So there's problems with joint defense above and beyond. I mean, there's reduced cost, but you got to really work with your counsel. You got to work with all the experts. You're going to have to work with everybody and make sure everybody's on the same page and really train your experts, even if it's not your expert. If you're having counsel A handle expert B and you're handling expert C, you got to make sure you're participating in working with the preparation of that one expert that you don't have the full control over, so that he's fully prepared and knows what to handle or how to handle and what to do during depositions, during cross-examination at trial, where they try to do these little tricks to try to get opinions out of him that really wasn't, what he was set up to do, but he's an expert. He's up there. He should be able to opine on it. So you do, to Linda's point, you give up control, but you want to try to really stay in as much control as you can.
Jumping in, this is Deanna, jumping in and providing just a few additional in-house thoughts on the cost subject in joint defense groups. On cost, a lot of times what we do is when a complaint is filed, we will reach out directly, even before retention of counsel, reach out to the other side and ask them point blank, what are you looking for? What's your demand? And that'll often help us gauge, how aggressive they may be once we get into litigation, whether we can reach a point, even pre-filing of an answer or motion to dismiss, if this is something we can settle out on in a fairly nominal amount. You know, there are companies that do have a tendency or a strategy of settling out early and seem willing to pay out nominal, say 5-figure amounts to get rid of cases at the very outset. And then there are companies, I think, that don't want to set themselves up as having a reputation for doing that, particularly for larger NPEs that have many subsidiaries and file, you know, serial cases, the various patents in their portfolio. That may hold out even if the balance sheet, it's going to be more expensive to litigate a case than to settle out at that 5-figure amount. And then on JDGs, I agree that a lot of times there can be efficiencies and cost savings, and oftentimes for us, that does factor into our decision making on which outside counsel to go with. If there is a possibility of joint representation, that often is particularly appealing. If you have, you know, 3 to 5 parties sharing counsel, then there's quite a bit of cost savings, arguably, on joint action items. With that being said, it's also important, I think, though, to keep informed of everything going on. That the division of labor is quite helpful, but a problem arises if one defendant settles out before the others and was managing or running a significant part of the analysis or the case on the invalidity side, for example. Sometimes in their settlement agreement with the other side, they're bound to not discuss the case or share strategy with the remaining defendants, which obviously will put everybody else in a bind. So it's important to just keep in the loop on everything going on, even if you are not the party in the JDG responsible for particular areas of the case.
Great points.
And I will say, though, having been in a joint defense group and having, you know, been a while ago when this actually first started happening, and we were like, what's going on in the Eastern District of Texas? You know, the firm I was with, we handled everything. And that's actually what the non-practicing entity was looking for, was that specifically, like, who was in charge of things. Like, and it was really obvious back then that the firm I was with was controlling everything and did get that early settlement. So they are very well aware of the damage they can do to a joint defense group by settling with the one handling everything. So that appearance is important too.
So that takes us into one of our last topics, which is administrative proceedings, which we talked about it briefly throughout the course of this webinar, is, you know, the post-grant proceedings. And just real quickly, since 2012, one of the biggest post-grant proceedings that's still in place is the inter-party review. As the Patent and Trademark Office statistics show, I mean, CBMs and PGRs just make up a fraction of the overall post-grant proceedings still filed to date. CBMs obviously are going to fall out within the next 2 years as the sunset provision expires, and it doesn't look like they're going to renew it. So you're going to have IPRs and basically PGRs. And overall, the petitions being filed by technology is still overwhelmingly electrical/computer, and that's mainly because a lot of those are software related or control related, microprocessor related. And typically those type of arguments, they're not really anticipation 102 arguments, they're more obviousness, where you have to combine multiple references. And in high stakes litigation, making obviousness arguments to a jury, you're just going to get lost, glazed looks from the jury. Your best place to take those type of arguments would be back in the patent office in front of the panel of, you know, 3 patent judges, where you might have some success in front of them with respect to an obviousness argument. So that's why, you know, 64% of the total petitions filed to date still involve electrical/computer. So a couple of advantages to IPRs, as Linda stated earlier, is it's a fast resolution, lower cost. You get a group of expertise of, you know, a set of 3 patent attorneys is going to be your panel of judges. They're all well versed in patent law as well as technically versed in certain industries. So typically you'll get somebody on your panel if it's mechanical related or chemical related type of patent. Typically on your panel you'll have somebody whose background expertise is in that field. Again, they are well versed on the law of obviousness, and they have no problem arguing patents are invalid based on obviousness. If anybody's ever looked at the statistics from 2012 to present, I I think they still have, after institution, they're still well above 60, close to 70% of at least a certain portion of claims that were petitioned for are found to be invalid. One of the new interesting aspects I'm going to let Linda touch on a little bit is the claim construction aspect that's changed over the last year.
Well, now, before the claim construction was a different standard between the patent office and for the district court. And so it sort of gets you, if you believe that that this technical expertise of the judge panel, you can get a claim construction that could be and likely will be adopted by the district court, maybe not the ITC, who tend to be off on their own sometimes, but it gives you sort of a second chance. But one of the big advantages to the IPR and why non-practicing entities absolutely, hated the whole process was that it pushes this initial cost and risk to the plaintiff. And so it extends the timeline substantially. So it was a major pressure point to get settlement from a non-practicing entity. That can be changing, though, is going to the next page, sort of the disadvantages. There's some standard disadvantages, but one of the ones we wanted to talk about with time sort of short was that IPRs are kind of a moving target. They're relatively new. And one of the big things that may give people pause in filing them, as popular as they've been, to balance things out between a non-practicing entity and a defendant, is these motions to amend patent claims. Because if that increases as is expected, then the claims change during the IPR, you're going to have a whole another set of costs.
Yeah, so the big thing and what we've seen in the inter-party reviews is this amendment practice. And anybody who's been involved with these IPRs over the last 6 or 7 years probably recalls originally motions to amend were almost laughable. The patent owner got a 5-page response to address all the prior art that was known to them and explain why the patent claims or the submitted patent claims would be patentable over all the prior art, and they were never granted. That's starting to change with this motion to amend. It's a longer procedure, and what it's turning into now, it's a completely parallel proceeding to the initial IPR that you might file as a petitioner. And what that means is you could have double the cost. So you may be the petitioner, you may file a patent or petition of 103 obviousness against a patent. Patent owner files a motion to amend, motion to amend is granted, and all of a sudden you have a completely parallel IPR proceeding with that motion to amend where all the costs are going to be double. You're going to have the same set of costs. You're going to have a whole other set of expert declarations, motions, responses, replies, and trial.
And not just that, but if the claims are amended, now you've really thrown, if you like the claims and you're not in infringement position, that could be thrown out the window for your litigation.
And you also run into the 1-year estoppel bar with the motion to amend because it's the same patent. Now you have different claims. If those different claims survive and come out, it's not like you'll have an opportunity to file another IPR because you'll probably most likely be past the 1-year bar from when the initial infringement allegation was made.
And we should move on to ITC with just a couple of minutes. I actually wanted to go to the chart, the ITC violation findings. And the reason, one of the things that ITC is so popular, if you look, they're very plaintiff friendly. You look at 2011, the percent of violations was 35%, and you're looking at 2019, they're up to 74%. I mean, the fact that there's some people choose where to file suit, and by being a place that plaintiffs like to file suit has increased their importance. So they become, this is well known, and even though there's no damages, the threat of an exclusion order and the speed at which things are handled at the ITC, along with this higher likelihood of success for plaintiffs, has made it a very popular forum.
Yeah, it's really popular, especially with regards to non-practicing entities, because if they have a patent just on a small portion of a product, be it a windshield wiper on a vehicle, and they file suit and they win at the ITC, I mean, now you're risking possible exclusion order from the ITC at the Port Authority, where the Port Authority, is looking at a picture of a vehicle and they're going to just exclude the vehicle. And whether or not you replace that windshield wiper with a non-infringing windshield wiper, well, now you're going to have to go back to the ITC and you're going to have to go through a long procedure to get that exclusion order amended. So it's a very problematic, and one of the other problems with the ITC is how fast it moves. If you file an IPR from the very moment an ITC action is filed, you're not going to get a stay. ITC does not stay litigation pending an IPR. So you're likely going to get a full adjudication from the ITC. It'll probably be determined by the, once the ALJ from the ITC makes its determination, it goes to the 3-panel judge who either affirms it or may overturn it. And if that happens before the IPR, even if the IPR comes down during that process, it doesn't matter. The ITC doesn't usually care about it.
They don't care, even when it's been held likely invalid, they won't honor that, and they'll just continue to until the appeals are done.
And the problem with that is once the exclusion order has been issued, it's not like trial where there's a damage amount and you can say, I'm not going to pay until the appeal is complete. Now, once the exclusion order has been issued, the Port Authority will start blocking importation of that product, whether it be the entire product. And there's nothing you can do, even though you may have appealed and you may win on appeal. You're going to have that time period from the issue of the order through the appeal where the product is being blocked at the port.
And the other aspect that in-house counsel hates the ITC is that they get blocked from seeing a lot of it, unlike district court, where at trial, information is shown to the in-house counsel. They have very restrictive protective orders, and things go really fast. And so it feels a little bit crazed.
It feels crazed, and in-house counsel, to your point, Linda, I know they hate ITC proceedings because we can't provide all the information, and sometimes you can't make the most informed decision as an in-house counsel, on certain aspects of the litigation. And I know sometimes that feels like you're losing control over the litigation because you can't make those decisions. Sometimes you're making decisions based on no information whatsoever other than outside counsel saying we have to do X, and X is going to cost Y. And now you have to go back to the business unit and say we need more money because outside counsel said we do. And business unit says, well, why? Well, I don't know. They can't tell me. And so that's always a problem. And that's why ITC proceedings are very, very problematic for a lot of in-house counsel. With that, Deanna, do you have any other follow-up points or any thoughts on ITC or post-grant proceedings?
Yeah, and just one note on the interplay of ITC, IPR, and district court litigation. So, I think oftentimes patent holder will file parallel ITC and district court proceedings, and oftentimes, even in the Eastern District of Texas, you can get a stay if you file a motion to stay the district court proceedings pending the ITC investigation. If there are IPRs thrown in, historically the ITC is not granted stays. So keep in mind, as a defendant in patent litigation, you'd be defending the ITC proceeding and also moving forward with the IPRs. I have had one case, though, where the patent holder actually did not pose a stay motion. And so it may have been the first time that the ITC has actually stayed proceeding pending final written decision and appeal of an IPR decision. But unless the patent holder can't agree, which I think is more rare than not, you'll have to proceed with that and PTAB challenges at the same time.
All right. So just sort of concluding, if there's any questions out there, I'm not seeing anything in the messages, but that's basically, our experience in handling high stakes litigation.
Thank you, Linda. Thank you, Deanna. Thank you, John. There aren't any questions at this time. Thank you, everyone, for joining us for this presentation. Thank you to Brooks Kushman for taking the time to put together all of this great information that I'm sure will be very helpful for many counsel in the audience as they look toward, their IP claims. Have a great day, everyone.
Thank you.
Thank you.